Hi, thanks for using my court coach. I'm Sarah and I'll be your instructor today as we talk about the petition for custody and support of minor children, also known as Form FL-260. As with all our court forms, you want to fill in your identifying case caption information at the top. Leave the case number blank because this is going to be the first form along with the summons that's filed in this case. Once it is filed, the court will assign a case number and the clerk will fill that in. This is the form to use if you have already established a parental relationship and you do not need the court to make that finding, but you do want some custody and support orders. So in order to fill this out, you're going to list in one the name of the child or children at issue and their birth dates and age. If you need more space, you can always attach another page to this to continue on. Below, you're going to explain how the paternity has been previously established. So it's going to be one of these boxes. 2A, if you are married to the respondent and no action is pending in any court for a dissolution, legal separation, or nullity. In other words, you would choose this if maybe the two of you are separated, but you're just not ready to proceed yet to file for the divorce, legal separation, or nullity. You can mark box 2A. 2B, if the respondent and you have already signed a voluntary declaration of parentage or paternity regarding the minor children, you can use this form and attach a copy of that to this form. Truthfully, though, if that is your situation, I would advise filing for a petition to establish parentage anyway, because I always think it's a good idea to have a court order recognizing the parties as the proper parents of the child at issue. However, you do have the option of just filing this form instead to get those custody and support orders. To see if the respondent and you have legally adopted a child together, you could mark box 2C, or 2D if parentage has been established already in a juvenile court or governmental child support matter. Then you can just list that case number, the county it was heard in, the state it was heard in, and the country it was heard in, if not the United States. You do need to include a declaration under UCCJEA or Form FL-105 that should be filed concurrently with this form and the summons. If you're requesting child custody and visitation orders, then below is where you would fill out that information. You can identify which party you want to have primary legal custody or sole legal custody of the children. If it's both parties, you can mark joint. Same with physical custody. You can either choose one of the parties to have primary physical custody and joint if you want both parties to share in that. If you are asking for one of the parties to have that primary physical custody, then you should mark the box for visitation for the other parent. Below, you can include a proposed schedule for visitation. You don't have to. It's up to you. If you want to include that below, you can. You can also use the Form FL-311 to describe the custody and visitation orders that you are requesting. Again, you don't have to. I think it's sufficient to say that you want reasonable visitation. Hopefully through this process at some point you and the other party will either reach an agreement on your own, or if not, you'll go to Family Court Services mediation or some other mediation, and that mediator will assist you in coming up with a parenting plan. But again, you do have the option to be as specific as you want or as general as you want on this form. If you do choose to be specific in 4, there are some very specific orders you can request. You can request child abduction orders, in which case you also want to file a FL-312 form along with this. You can request a particular holiday schedule, and you can use the Form FL-341C to help you determine that schedule you want. Or again, you can just attach a description of what is the holiday schedule you would like. You can request other additional orders regarding custody, whether that be the physical custody or the joint legal custody. And again, there are forms that you can use for that purpose, or again, you can just sort of describe below what it is that you want to be ordered. And then if you are requesting supervised visitation, you can mark box 4I and indicate what sort of restrictions you want in place and why. And again, if you need more space, you can always attach a sheet of paper to this to continue on. If there's any other orders that are not specified above with respect to custody visitation, you can mark the box that says other and specify what those are. If you're asking for one of the parties to be ordered to pay attorney fees, mark the box that identifies the party that you think should be paying the attorney fees. If you're asking each party to pay their own, you can mark box 5B. The court does have the authority to make child support orders through this case, and line 6 is just telling you that. In line 7, any other orders that you want the court to make with respect to custody or support, you can specify those in line 7. Like I said, this will be served along with a summons, and there's some automatic restraining orders that go into effect with that summons that we'll go over in a separate video. And finally, you want to print your name at the bottom and sign and date this form. This form will be served on the opposing party with a blank response to this petition that they can fill out. So I hope you found that helpful. Good luck.